representing yourself in any proceeding, civil or criminal, is really just an awful idea. Either right before or in the middle of trial and says, uh-oh, I made a big mistake. I have no idea what I'm doing. Will you please help me? Hello again, it's Lana Manitta with Rossen Law Firm, and I'm here to talk today about a defendant's right to defend themselves at trial. Obviously, this is something that we do not recommend, but it is an interesting topic because it's a little bit more complicated, I think, than most people believe, and with good reason. So before we get started, I want to remind you to like and comment on this video and subscribe to our channel. We try to provide a wide variety of videos on different topics relevant to criminal defense, both in the federal jurisdictions and in South Florida. So, there's an old saying, the lawyer who represents himself has a fool for a client. Well, that goes for just about anybody, including lawyers. Representing yourself in any proceeding, civil or criminal, is really just an awful idea. Not just for procedural reasons, but it really requires some detachment from the gravity and the weight of the proceeding and the potential consequences. It requires that more intellectual and less emotional drive be put into the preparation and the presentation of a case in court, especially if we're talking about federal criminal defense or defense on a state felony. It just requires not only skill, but just that little bit of detachment that we have to have as a not neutral party, because your lawyer cares very, very much about what happens to you, but we're not the person who's in the mess. We're not the person whose life is necessarily going to be destroyed by what might happen. And that's just not the position that anybody should be coming from when they're presenting to a jury or a judge or arguing motions or needing to stay within sort of the parameters that are set by the rules of procedure and, what is properly argued before a court. So for this reason, because it is not something that's advisable, the courts don't take it lightly when a defendant in a criminal case says they want to represent themselves. However, everybody has a right to do it. It is absolutely your right to defend yourself if you want. You do not have the right to just any attorney that you want. You have the right to an attorney that you can pay for. You have the right to be your own attorney. But if you ask the court to appoint you counsel, you do not have the right to choose the counsel that is appointed to you. So that is often the context in which this request to represent oneself comes about. An individual will not have the means to hire counsel, or their means have been frozen because they're subject to seizure and forfeiture by the government. And so they get appointed counsel under the Criminal Justice Act in federal court or some state provision for court-appointed counsel. So this may be a person who is normally a person of means. They may have a lot of education, and they are butting heads with their counsel. They feel like, hey, I didn't choose you. I'm going to represent myself. I don't really think it matters how much education you have, including even legal education. It is simply not advisable that you represent yourself. And so the court won't just say, okay, go ahead, counsel, you're excused, defendant, have at it. They're going to undertake what's called a Ferretta hearing to determine whether or not you really can do it. And it's a hearing that's undertaken. It's named after a case, a Supreme Court case, United States Supreme Court case, Ferretta versus California, in which the defendant wanted to represent himself. And the Supreme Court sort of set these guidelines for the inquiry that a court should make before allowing a criminal defendant to represent themselves. So I'm going to be looking down at my notes because I want to give you the suggested questions that need to be asked and need to be answered with the right answer in order for a judge to approve pro se defense, as it were. So, the defendant will be asked if they've ever studied law. It's not required that they have to have studied law, but it's relevant, obviously, to the consideration, because if the answer is yes, then the answer might be no to some of the other questions, but it'll be less of a major concern if the person actually understands how to do the research and how to find out the things they don't know if they've already studied law. They'll be asked if they've ever represented themselves before in a criminal action. They'll be asked if they understand the charges against them. They may even be asked to explain in their own words what they're charged with, what the maximum penalties are, what the elements of those offenses are, because it's one thing to know, hey, I'm charged with assault, and it's a completely different thing to know what the elements of assault, what the things that the government actually has to prove are. And it's not, oh, I hit somebody, right? So, that's just one example of the difference between knowing what's on your indictment and knowing what actually has to be defended against at a trial. The defendant will be asked, do you realize that if you're found guilty of these offenses, I, the judge, can sentence you either concurrently or consecutively, meaning your sentences can be stacked on top of each other. Do you realize that if you defend yourself, I, the judge, can't help you? I can't tell you when you should be objecting, and I can't object to things that you should be objecting to. I can't advise you on anything with respect to the law or your presentation of your case. You will have to conform to the procedural rules, the rules of evidence, the rules of decorum in the courtroom, and you will not have any assistance. You're basically expected to know what a lawyer is expected to know and to behave accordingly. The judge will ask if you are familiar with the applicable rules of evidence in that court, case law that's applicable to your case, and the procedural rules that are applicable to your case. And we'll ask you if you've read them, if you've absorbed them and are ready to abide by those rules. And then the judge will likely go into different parts of trial practice that aren't commonly thought about by pro se litigants to ask whether or not the defendant knows what they are and is prepared to conduct them. The most important being voir dire, which is the process by which a jury is selected. Most people don't even contemplate this process, let alone know what this process is when they decide they're going to represent themselves. And so the judge will ask, do you know what voir dire means? Do you know how to conduct voir dire examination? Do you know the grounds for excusing a juror for cause? Do you understand what a peremptory strike is? Do you, and then the judge will often go into evidentiary rules, and some of the more important ones that come up in almost every trial. Do you know what the definition of hearsay is? Most people don't, and a lot of lawyers don't. A lot of lawyers make hearsay objections that are completely off base. And so, a pro se defendant is likely to get it wrong. Do you know not only what hearsay is, but do you know the exceptions to the hearsay rule? Half a trial can be won or lost on those two questions. So they're really important to know, and it's important for a judge to inquire whether or not a criminal defendant who wants to represent themselves knows these rules. Do you know the best evidence rule? I can tell you that's another one that a lot of lawyers do not understand, and so it's really unlikely that a pro se litigant is going to know it. Impeachment. This is when a witness has said something that's not true or is in conflict with something they've said before, and you want to impeach them. You want to show that they are not credible with respect to that answer, and then argue later that that undermines their credibility altogether. But the judge is going to want to know, do you know how to do it properly? Again, this is something that even seasoned attorneys often do wrong. Impeachment with a prior inconsistent statement, it's done wrong all the time. And the judge is not going to want to be stopping and starting a trial to teach you, and won't teach you, how to do these things correctly. And so a pro se litigant is going to be asked ahead of time whether or not they understand this. They'll also be asked, do you understand when character evidence is appropriate to be brought into trial? Do you know how to make objections? It's not like television where you just jump up and yell, I object. And different judges have different ways that they want objections made in their courtroom. There are things called speaking objections that are not allowed. And usually what you see on television is a speaking objection. Your Honor, I object. He can't say that because that's a speaking objection. You're actually not supposed to do that. And again, this is one of those things that even attorneys do wrong. So the judge is not only making sure that you are going to be protected by competent representation if you represent yourself, but that the trial isn't going to go completely off the rails because, you have no idea what you're doing. The judge will ask, do you know how to make motions for judgment of acquittal? Do you know how to move for a mistrial and when that might be appropriate? Do you know how to proffer evidence? Do you know how to protect your record on appeal or for appeal? Do you know that if you don't make certain objections or certain motions, you are waiving those objections for later? You may be waiving arguments for the appeal of your case, and may ask things such as, do you know the order of trial? Do you know the process that trial will take? Now, if the defendant who's asking to go pro se can answer all these questions satisfactorily, then it is, it's likely that the judge will let them represent themselves. In some instances, if there has been counsel appointed, they will be asked to stay on as what's called standby counsel. And that's basically an attorney has no authority to do anything on behalf of the defendant. The defendant has been given the right to defend themselves, but they'll be asked to be present for trial and basically literally just be sitting there and standing by in case the whole thing goes off the rails. And the defendant, which has happened, turns to counsel either right before or in the middle of trial and says, uh-oh, I made a big mistake. I have no idea what I'm doing. Will you please help me? And that is what they're there for. The trouble for standby counsel is they haven't been able to file any pretrial motions. They haven't been able to try to suppress anything. They haven't been able to try to limit the way the evidence is going to be presented because their hands were tied by the pro se litigant representing themselves on the way into the trial. And now the litigant has said, this was a really bad mistake, please take over. And the attorney is faced with, evidence that's coming in that shouldn't, and the objections may have been waived. A record perhaps has already been destroyed for appeal. It's not a situation that A, an attorney wants to be stepping into, or B, any defendant should ever want an attorney stepping into. And I say this because, obviously the moral of the story is not to represent yourself in any proceeding, but especially a criminal proceeding. The stakes are simply too high. The emotion is too high. Having the stake that you have in that proceeding is simply too important to put yourself in a situation where you are both the defendant and the attorney. Okay. You also might say something that sort of pins you down and destroys your Fifth Amendment right in the course of your cross-examination, for example. So, there was actually an example of a gentleman who was accused of shooting people on the Long Island Railroad years ago, and he represented himself, and he insisted on referring him to himself in the third person, because he was really trying to separate himself as lawyer from defendant. And you can't do that. It backfired horribly because he would ask victims isn't it true that you did not see the defendant, shoot you? And the people on the stand would say, no, I definitely saw you shoot me. And this went on with just about every witness that took the stand. And frankly, it was more compelling than it would have been if they had said to a defense attorney, I saw your client shoot me. They pointed at the defendant right in his face and said, you shot me. And so, it backfired in just every way imaginable. Plus, he wasn't a very good attorney. But I hope that if you are facing any kind of criminal charge, you won't even think twice about the notion of representing yourself, and you will call counsel as early as possible to get them on to help you and get through this, because otherwise it's likely to be an unmitigated disaster. So that's just a tip. It's not to chase business. It's to make sure that people aren't just destroying their lives by representing themselves in court. If you or someone you know is facing criminal charges, make sure they're not representing themselves and call Rossen Law Firm, and we will be able to help if it's a federal case or a South Florida state case. As always, thanks for watching. Like and comment on the video and subscribe to our channel.